Good afternoon, everyone. My name is Jeremy Bloom, and I'm joined by Toby Hedden, and we're IP litigators at Bristows. And we are going to speak about that case that's been clogging up your LinkedIn feed, Getty Images and Stability AI. No doubt, some of you know the outcome. There was no copyright infringement, but there was trademark infringement. Now that's a very, very high level summation of the case. Today we're going to unpack some of that, and we are trying to distill a 200-page judgment in our 20 minutes. So it's going to be fairly high level, so apologies for those who want to go into the details. We're here to discuss it afterwards. And one of the things we are going to cover obviously is the judgment itself and what's in the judgment. But what we found probably most interesting and exciting for the future is what was not in the judgment and what issues are still live as a consequence of the case, certain things being abandoned or the pleading not covering certain things. So we're going to actually spend a bit of time focusing on the things that are not in the judgment. And Toby, maybe you could kick off.
Of course, thank you, Jeremy. And we do like each other. We're just standing apart for visual effect. But so the first claim, which didn't ultimately end up in the judgment, related to what's known as training and development of the AI, which was essentially this. Getty said that Stability AI had copied and used millions of its images when training its diffusion model. Now, it's a bit of a pity, really, because you can see there's potentially quite a lot of jeopardy in this sort of a claim where you're talking about millions of documents. So we were quite looking forward to finding out what the answer was, and I think lots of other people were. So why didn't it proceed? Why did Getty, shortly before the closing of the trial, elect to drop the claim? The problem for them was this. They had not shown demonstrably enough compelling evidence that any of this activity for training and development had occurred in the UK. Because of that, the UK court would not have had jurisdiction to decide the claim. So they fell short on the evidence, unfortunately. What that effectively means is that it's still an open issue. So there could be another case that comes along which revisits that issue and looks at it again. And there's also some other points which I think you're going to touch on about a consultation that's going on as well. So I'll hand back to you, James.
So the second aspect that was abandoned before trial was the so-called output claim. And this is best explained as there's this image of one of the claims relied on, and that is when a user of the model is prompting the model. Here's the prompt. This was a real-world example which they'd found an actual person had entered this prompt into Stability's model, and an image is generated. And the allegation was that this image, as a result of the prompt, is a reproduction of a substantial part of a Getty copyright work. Now, there's lots of issues in the case about contrivance and whether these were actual significantly enough real-world instances of Getty images actually being copied, because most of them were actually contrived by the lawyers for the purposes of the litigation. But they did actually manage to find and identify some real-world examples. But this claim, as I mentioned, was abandoned. I mean, the legal basis for it was an allegation that Stability AI was the one who was actually communicating to the public the copyright work, and as well that they were authorizing or reproducing authorizing the reproduction of a copyright work. So that claim did not go forward. One of the reasons was, as I mentioned, they didn't have that many instances of real-world examples. Lots of it was contrived. It wasn't a significant body of actual issues. So what happened as well? Stability blocked the prompts. So the images that were in the case were generated as a result of certain prompts that had been created. Now, Stability put blocks on those prompts, so as a consequence, the alleged acts of infringement were no longer ongoing. So there was no meaningful relief that could actually be granted by the court. There's no need for an injunction. So the judgment actually alludes to this, and so potentially one of the reasons why it was dropped was there's no longer any meaningful relief required. Now that's a bit of a shame because we think that's still pretty interesting aspect of the case that could have been argued, but for various reasons they did drop it. So, Toby, what else happened?
So, well, what else didn't happen was that Getty didn't plead a case for what's known in AI parlance as memorization. Some of you may have heard of that, some of you may have not, but I'll explain it very briefly. So, an AI model, such as Stable Diffusion, is not a database. So, if you look under the bonnet, you won't see copies of all the works that it's been exposed to during the training process. What it comprises of is a series of weights and parameters. And during the training process, the works that it's trained on make an impression on those, and that influences what a user sees in response to a prompt that the user puts in when they enter a prompt. Sometimes when a user enters a prompt, it can render an output which looks very similar to one of the materials or some of the materials that are used in the training process. So although the model doesn't contain a copy, it produces something similar to the copies that it was trained on. So that's the phenomenon of memorization. Now, Getty didn't plead a case for memorization in this case, so the court didn't have to decide it. We will come back to this, though, because in relation to one of the copyright claims that did proceed, or the only one that was left, essentially, the judge made some comments which we think may be relevant to any future claims for memorization. So we'll come on to that.
Yeah. So with that in mind, so the heart of the original complaint was not actually in the judgment. So still lots of interesting issues to come in the future. One thing to mention is that you may have heard about the consultation that took place last year. The government was seeking views on changes to copyright law in light of AI developments. And so about 11,500 interested parties responded to that consultation. One of the key issues was whether there should be an expansion of the text and data mining exception. And I haven't seen all the responses, but what I've heard is that the overwhelming majority of people who answered and interested parties who answered were against that. So we're expecting the government to give their views in about March this year. So this is very much a watch this space to see how the government reacts in light of the answers to that consultation. So that's what wasn't in the judgment, and one eye to the future. Now let's look what's in the judgment.
That was one of the most responded to consultations ever as well, incidentally. But, so in the judgment itself, as I mentioned earlier, as Jeremy mentioned earlier, the output claims were dropped. That was where the filters were applied, and I mentioned that the input claims didn't go forward because of the jurisdiction issue. That left what's called a secondary infringement claim for copyright, and essentially it ran thus, that Stability AI had imported into the United Kingdom an article which was an infringing copy, so bear in mind those two words, article and infringing copy, because we'll come on to those, when the user effectively downloaded Stable Diffusion in the UK. Now this was quite an interesting claim because the court had to decide whether Stable Diffusion as a piece of downloaded software was an article. Now you can imagine an article, you can think of a good or a product or something physical that's imported. This was something intangible, it wasn't physical. So the court had to decide whether it was an article, and I think perhaps unsurprisingly the court said, yes, it's an article. Indeed, it would probably been a bit odd if it had concluded otherwise, because that would render anything intangible that's imported in whatever way, through downloads or access through a website, would be rendered copyright free because it wouldn't be an article. So that's a relatively uncontroversial decision. In relation to the second point about whether that article was an infringing copy, this is where we come back to the point about memorization. So the judge concluded, in summary, that the Stable Diffusion model was not an infringing copy. And the reason on which she reached this conclusion was because it simply just did not contain copies of the copyright works in it. As I said earlier, you look under the bonnet, you see nothing. The way Getty had pleaded their case was to say, well, that doesn't matter because it was exposed to copyright works in the training process. That makes it an infringing copy, which I always found slightly difficult as an argument, but that's what they advanced. The judge shot that down. So the claim failed on that basis. But what we found quite interesting was some of the judge's comments in relation to the secondary infringement claim, and I'll read them out verbatim here. So she said, the model itself does not store any of the copyright works. The model weights themselves are not an infringing copy, and they do not store an infringing copy. They are purely the product of the patterns and features which they have learnt over time during the training process. So that begs the question, if in the future a claim for memorization is advanced, will that wording have any effect on that? You can imagine an AI developer would point to that and put it at the front end of all of their arguments and say, well, look, the issue's kind of already been decided by the judge, albeit not in the context of that claim. So I think there's an argument for that. Now, curiously, very shortly after the Getty decision was handed down, there was a case in Germany involving OpenAI and a collecting society, Gamma, where a claim for memorization was pleaded and was advanced. And in that case, the German court, I think it was the federal court or the regional court in Munich, said, well, we think that that is sufficient to found a claim for copyright infringement. And they said, it doesn't really matter what's in the model itself. If what it spits out is demonstrably similar to a training input, however it happened, it must be a copy. So they took a very broad understanding of the meaning of copy, and that's typically what we do under EU law, has a very broad meaning. They said, because it's reproduced something, because it's reproducible, it's capable of reconstituting something which looks similar to what it was trained on. That was sufficient, and therefore there was a claim for copyright infringement that succeeded.
I'm just going to cover off the trademark infringement piece, what was in the judgment, and I'm just going to go back to this image. And so you can see here that, I hope you can see, there's a faint watermark, the Getty Images trademark. And what Getty Images, what their business is that they enable people to obviously use their photographs and images, and often they put a watermark in it. So the claim for trademark infringement here was that when a user would prompt Stability's models, an image was synthetically generated, and in that image was Getty's registered trademark. So the allegation was that is trademark infringement. Now, I'm going to cover two key aspects of trademark infringement without going into all of the details in the judgment. And I think these are the two most important aspects in the context of technology. The first is the meaning of use. Trademark infringement requires there to be use of a trademark in the course of trade, use in relation to goods and services. Use is an absolutely central function, and there's lots of cases over many years from the Court of Justice, in particular in relation to the liability of platforms, about who is using a trademark on an e-commerce platform, for example. And so the legal concepts are all about control. Is there direct or indirect control by the party using the mark? Is there some sort of active behavior going on? The use ultimately has to be in one's own commercial communication. So these are all the legal principles that have come out of the Court of Justice and been applied in the UK. So the judge in Stability looked at those principles and then applied them to the case, as you'd expect. And there are a couple of things that I think really stand out in this case when looking at the meaning of use. The first is, in this case, the user does have an element of control. And the judge accepted that. There is an element of control. Obviously, it's the user who's prompting the AI model to do certain tasks. Now, in this case, nobody wanted the Getty trademarks in the image. It was accepted by both parties. Stability weren't looking to have this in their images, and a user really didn't want this thing cluttering up the image they were trying to generate. So in terms of control, the user didn't want this. So the judge thought, well, a user doesn't actually have full control here because they are getting something they don't want. Now, in contrast, the judge looked at what Stability had done. And it fundamentally turns on the fact that Stability's model is designed to learn on patterns. And to do that, there's obviously the training aspect, that the weights are trained on data. And it's the weights that then dictate the functionality. So ultimately, it was Stability that were responsible for how the model had been trained. And it was their decision of what training data to include to train the model. So the judge said that meant that Stability was the one who was using the trademark. Now, that's all fine, but what about this as an alternative proposition? What about a case where the user doesn't actually mind if the trademark appears in the synthetic generated image. So here, we put a prompt. We're not saying give us, this prompt here you can see is a bit of a nod and a wink to paying homage to the world's leading sports brand. Adidas came up, so Nike might not be that happy about that. And so the question here is, the user here is actively prompting and saying, give me this. It's not a question of not wanting a trademark appearing in the image. So I think there's still lots of scope to say what type of use is actually happening. It could be determined by what prompts are actually being entered into the model. So interesting things to come, I think, on use. The final comment on the trademark infringement claim is the concept of likelihood of confusion. And in this case, the judge decided that there are 3 different average consumers. I won't go into all the detail there, but across the spectrum of the average consumer, there was going to be a likelihood of confusion because each consumer would have wrongly thought that there might be some sort of collaboration between Stability and Getty, that Getty may have actually licensed Stability to use their images at the training stage. So when this model was trained, that ultimately they were allowed to use these Getty copyright works, and that was a wrong belief. So the judge said there was a likelihood of confusion. Now, again, I think this is a very unique case because Getty's whole business model was in the business of licensing images. So using this counterexample, again, Adidas's business is not about licensing images. They are in the business of merchandise. So would a consumer who has prompted a model to give an image of a marketing image which pays homage to the world's leading sports brand, is that consumer going to be confused? Would they really think that Adidas have some sort of collaboration with the model at the training stage to ingest this data and then wrongly believe that there was this collaboration? So again, I think another key concept is the likelihood of confusion. I think this case, it was found in limited circumstances, but in future, I think it's all going to be very fact dependent. So that is our skip through of the Stability AI Getty Images case. Obviously, lots of things we haven't discussed. We do think it's a very much work in progress, and lots of things will come out in the future cases as well. We're really interested in the government's response to the consultation, which should be illuminating. And as well, the final point, this has been appealed, this judgment. They have permission to appeal on the copyright aspects, so we should see what the Court of Appeal says as well.